Good afternoon. Thank you so much for joining us. Thank you also to Startup Boston for inviting us back again this year. My name is Andrea Reed. I'm of counsel with the law firm Lando and Anastasi. I will be moderating this wonderful panel today. We have 4 very knowledgeable people. To start, my background, I'm an IP litigator. I spent very many years as outside counsel at an international law firm, and then a little bit of time in-house as well, also practicing IP law. And potentially relevant or interesting to the people here, my technical background is actually in bioabsorbable polymers. So I spent quite a bit of time manufacturing products for orthopedic surgery and that sort of thing. So today we have a very interesting and important topic, which you all know how important it is because you're here today to learn about it. It's FTO, freedom to operate. And our goal for this session is to help startup founders and to help their colleagues learn, get the knowledge and the tools that they need to implement FTO as part of their strategic path to market. A couple housekeeping things before I forget. We're targeting 1 hour. I'll probably leave about 5 minutes at the end for questions. Hopefully we can get to all of them. If not, I'm very, very sorry. And then we have a couple lawyers on the panel. You all know this, but nobody's providing legal advice. So just keep that in mind. I have to throw that disclaimer out there. So without further ado, I'll introduce everyone on our panel. We have, I'll start with Brian Hess. Hang on, I'm going out of order. I'm saving my colleagues for last. We're going to start with Brian Hess right here. Brian waved to everyone, so they know who I'm talking about out of order. Brian is founder and CEO of RevBio. We also have Jay Cahill, IP counsel of Mark Forged. And then my colleagues, Peter Lando, a founding partner of the firm, and Angeline Larkin, a partner at the firm. So what I'll do now is ask each of the panelists, in whatever order you like, to introduce yourselves, tell us a little bit about what you do and about your companies. Who wants to start? Brian, I'm starting with you.
Sure, why not? Again, my name is Brian Hess. I'm with RevBio. We're developing a novel biomaterial. We're using this material to treat many different conditions in orthopedics, dental. What makes our material unique or interesting is it's got load-bearing adhesive properties. So think about a fractured bone. You could literally glue that bone back together. But what makes it dually interesting is the material is regenerative. Over time, the material becomes bone in the body. So it's a novel material, it's a platform technology. We have a range of indications. And so what's relevant for this panel is that we've spent a considerable amount of time and money to sort of develop our intellectual property for this material, especially as we pursue many different indications. And I've worked with Lando and Anastasi since the founding of the company just over 8 years ago. Thank you.
Jay, your turn.
My turn. Hi, my name is Jay Cahill. I am in-house counsel at Mark Forge. We are a leading provider of 3D printing materials and printers and software. The focus of our portfolio is patents, but I'm an IP counsel for the company. The focus of our portfolio is patents, but since I've been there, we've been involved in a number of areas that I think would be relevant to the panel, including we've been involved in a number of litigations. We've been involved in acquiring a number of companies. So relative to freedom to operate, there are a number of key issues that we've been addressing that I think would be of interest to the group.
Thanks, Jay.
Hi, everyone. My name's Angeline Larkin. I'm a patent attorney. Is this better? Great,
Much better.
I'm a patent attorney at the law firm Lando and Anastasi. I'm a partner there. My background is in life sciences, so I've got a graduate degree in bioorganic chemistry. I also spent some time in industry working as a chemist for a number of years. And when I finished all my academic training, I decided to join a law firm and go to law school. So I've been in school for many years. I help run the life science practice at our firm. So I'm happy to answer any questions related to FTO generally. But if you have any particular questions about how that might look in a life science space, which could be a little bit different, just as a quick note, life science products, if they're especially going to be administered to people, can take longer. So that's sort of my area. I'm really happy to be here today. Thanks.
Thanks, Angeline. All right, Peter, you're last.
Peter Lando. Yeah, I've been an intellectual property attorney for over 30 years. We formed our firm 20 years ago, and those prior to all of that, I was a chemical engineer, um, received my MBA, and then went on to law school. And it's really, I still feel as jazzed today as I did then when it all comes together, business, law, and technology. And so it's been a fun time for 30 years. I've handled hundreds, if not more, FTOs, and whether they're single innovations or new companies in a variety of technologies. As I said, my background is in chemical engineering, but it's much broader than that these days with technologies converging, and it's an exciting time.
Okay, that's great. Thank you. I'm going to start with an easy question. This one's for Peter. All right. What is freedom to operate?
Well, it's a bit of a misnomer, of course, and whoever coined it, congratulations. It's not really freedom to operate, but it is certainly an increased comfort level to launch, whether it's a new product, company, some innovation into a marketplace. The ability to have some level of comfort that you can do what you want to do. I won't say an absolute freedom, right? Especially given the resources and the amount of technologies out there. I began practicing before there was a functioning internet. So now we can find prior art in any corner of the world. But freedom to operate is basically the ability to do what you want to do.
Or to perform a risk risk assessment too and decide.
Well, absolutely. It depends on the context, but so product or service, yeah, absolutely.
And then I'll throw this one to Angela, the outside counsel on the other end of the table. Are FTO searches or opinions legally required? And if they're not legally required, why bother doing them?
I would say they're not legally required. They're oftentimes, though, invaluable to a company. Sure. Is this okay? Thank you all for the feedback, for not letting me go silent for the whole. So FTOs are not legally required, but they are really, I think, invaluable for the development of a product and the growth of a company. Kind of elaborating on what Peter said, the freedom to operate analysis really gives the company some insight into what the landscape of the technology looks like. And so, for example, if I were interested in moving forward with the development of a cup, I might want to know what the other cup developers are doing, what the patent landscape is, if there was some other position out there that would prevent me in a particular jurisdiction from making and selling my product. So it's not legally required, but it's very helpful. We'll talk about this over the course of the panel, but thinking about when you might carry out an FTO, the scope of the FTO, and the format of the opinion rendered, these are all really important things. And depending on when you do them, the output might be different. So
that's great. Thanks. I'm going to segue Angela's answer into my question for Brian, which is when would you want to do an FTO?
Well, I mean, you have to really be thinking about it at all times. We probably will talk about this too, but like a formal written opinion letter, maybe someone's thinking like that's a tangible thing that you would get out of an FTO. We haven't formally done that, but at the same time, we know of all the data that's out there, we believe, that sort of circles or is around our patents. And that started early on, right? We knew we had a novel technology, we didn't know the white space. We kind of knew that others might be embarking on it just based on research and sort of what we think would be disruptive. And so knowing that, you're always looking at who's out there, how they're patenting, where the research is, and that gives you insight into where to focus your effort, where you would focus your resources on developing your own intellectual property. So early on, obviously, is the answer, but it develops and is sort of lingering, and it's in the back. It's sort of in the background, the entire company, right? So from the initial founding stages all the way through the maturity, and I'm sure Jay can talk about that as well.
Brian, I liked a phrase you used. It was white space. What do you mean by white space?
Well, the way I just look at it is sort of like, as Angela said, there's other cup manufacturers out there. Like, what's novel about their cups, right? And so, but then you kind of look back at yourself. Well, what's unique about our cup, right? So, the sort of available space in between the crevices. There may be claims out there, and so those are little nodes that crowd, maybe what this open canvas is. And so, what remains in between those nodes, I would sort of say, is the white space.
That's great. Thanks.
Yep.
That's a word you hear a lot with respect to FTO. Jay, I'm going to include you now. I think it's been a whole 5 minutes since I asked you a question. This is the trouble with 4 panelists. Jay, tell us some of the purposes that you've seen FTO used for, because there's a whole lot of purposes for it.
Sure. Let's see. I guess for me, I've used it for a number of areas, and I guess one of the key reasons that you would look at it is for product and product development. So if before you launch onto the market, one of the things that you want to think about is an assessment of your product relative to what else is on the market. You want to have an understanding of what the patent landscape is. It's a good word, and I'll carry it. I'm sort of a visual thinker, so I would think if you consider where your product is going to be, the patent landscape would be where there are, if you think of where there are patents on the map, those areas would be red. You would want to think of those areas as areas you need to avoid. The areas that are not patented, those are areas that you can freely operate in. That's sort of the what you would think of as a landscape. So as you maneuver around them, those are areas that are commercially free. There are other areas that have public disclosure in them. Those are other areas that you can also move free in terms of your freedom to operate in. That is the kind of opinion that we'd be developing around a product. You want to be able to have some comfort that as you develop your product, that there isn't going to be somebody else out there that has patented claims in a particular jurisdiction that you can might potentially sue you. So that's one thing that you want to be able to think of. Another area that you want to be able to look at is if you're looking in for purchasing a company, or looking at licensing a technology, those kinds of areas where the technology isn't yours, but you're looking at evaluating somebody else's technology. Same exercise. You want to have some understanding of the technology, and you want to be able to step out there to look at it and evaluate that space in the same sense. You don't want to be out there looking at it and have an investor or have someone else inform you that you don't have freedom to operate. So you want to be able to be out there, get knowledgeable in the area, get knowledgeable of the landscape, the patents that are crowded in that space, so that you have an understanding of what that freedom to operate is in those areas.
Thanks, Jay. Brian and Peter, you both look like you want to say something to add on to purposes of FTO. I can tell. Peter, it's your turn to talk.
Are we being equitable? Okay. No, it's fine. We'll get there, I'm sure. We've been on several panels, Andrea and I, and she scolds me when I get ahead of the group, so I'm holding tight here.
Or when he talks too long, or doesn't let me look at his watch.
Okay,
All right, it's Brian's
the list. I
going
didn't
to
know
go.
about that.
Peter's giving me a hard time. Brian, do you want to add anything on
I would
purposes?
reinforce what he said, because investors, right, startups, you're looking for money, and you have to convey some sense of credibility, right? So that you've done your own homework, and someone's going to ask the question, whether they know it or not, and how you answer is going to be a judgment against you. They may be just looking at your competence, right, as a manager, as an executive. So the answer to the question is fundamentally important, but how you answer, your preparedness, they may look at you and say, he really doesn't have a clue about this. I know about these things, but he's acting like he does. So I would just say, like, from a startup perspective, you need to know what you don't know, and you need to know how to present yourself to these investors. So I was just looking at, when you said credibility, I was thinking that was a good point.
I think what I wanted to add was that it's not so static an exercise. So when we're talking about white space and can I operate in that white space? Well, is that white space even worth acting in, practicing in? And then I think what's overlooked often are what resources do I need to make my product and service work? So what's upstream and down? Who are my customers? Who are my suppliers? Who are my competitors? Real, actual, disruptive? I need to have a big picture. It's not just finding the space and jumping into that space, because it might be valueless. So we have to see, yes, that's available immediately, this space, but what will it allow me to do? And then, Jay, you mentioned license. It's not the end of the game, even if there is
Important.
somebody where you want to be. There's opportunities for license. There's opportunities for collaborations. IP, and this is what we're talking about, and I know the conversation has drifted into patents, perhaps rightly so, but this is currency today. So this is an opportunity for collaborations that you had not imagined. And as technologies converge, everything's connected, everything has an AI component all of a sudden, partnerships are formed, and 1 + 1 no longer equals 2. So it's an exercise that pays dividends. I'll leave it at that.
That's perfect.
I should stop.
No, that was perfect.
Okay.
I'll ask a question, Angela, and you can answer this because it's your turn, or if anyone else wants to jump in, they can. So the hypothetical is a company is approaching a funding stage. Pretend it's any funding stage. Are the due diligence requirements or expectations that investors are thinking about, are those going to be changing at different stages of funding? Like, for example, if you're at seed angel versus venture capital?
That's a great question. I do a lot of this work, so thank you for that. Yes, they would. So, for example, if you're a startup and you're maybe 1 or 2 people and you've got an idea, but you don't necessarily have any funding, and this is your first funding round or your first attempt at getting funding, usually the expectations of your knowledge of FTO are commensurate as to where you are in terms of your company. So, if I'm an investor and I see that the initial company has spent, let's say, all of its funds on FTO, but have done no product development, I might think that that might be an imbalance, and that might lead me to question the management style. So I guess what I'm trying to say is you want to be thoughtful about having FTO analyses as part of your strategy, certainly, but early days. Do you need me to speak louder? Is this okay? I forget where I was. I'm sorry. But essentially, the earlier you are in development of your product, usually, in my opinion, the expectations for your knowledge around FTO tend to be a little bit lower, right? Because first of all, if you're early in development, you might not have exactly the sense of what your product might end up being. You have to go through stages of development. If you're in the life science space, you have certainly stages of testing, whether it's on, in vitro or in vivo or in clinical trials. So your product will change over time to develop or work around any issues you encounter. So if you were to do a huge FTO analysis early on, that might not account for some changes to your product that would develop over time. So in my experience, as we counsel companies, we often say that we should certainly spend some time on understanding what the competitive landscape is around a product early on. You certainly don't want to blindly go into a space and launch a company if you don't at the outset have the ability to move forward, or if you're going to encounter some roadblocks. But as you develop, as your product starts to take shape, and as you raise more money, we oftentimes would advise more effort and more resources into understanding FTO. So it's developing, along with the rest of what you're doing as a startup founder, it's something that you're constantly revisiting and developing over time.
That's perfect. Thanks, Angela. Brian, I know you had some experience with different due diligence expectations with respect to FTO specifically at, say, the angel investing stage versus institutional investors. Do you want to share a little bit about your experience?
Yeah, well, like Angeline said, in the healthcare space, the products that we're developing take a long time before you get to market, right? So considerable amount of dollars and cents go into that, more like dollars. And and so, but the point on that is like your expectation in at least the healthcare space is you're going to need larger sums of money to get there. And they're going to want to know that, at the long end of all this, you're going to have a product that's protected and freedom to operate, right? So it does start early, I would say, and probably the size of the check, right? So we've had investors that haven't even blinked an eye. They think what we're doing is cool. They write a check. We've had others that they're very competent in what they're doing, and they know the questions to ask. And you need to be prepared to answer those questions. And so it has started early on, even in the angel funding round. Absolutely, as we've now grown to the scale that we're at, and we're looking for larger sums of money, VC money, upwards like 25, 30 million, that's going to be a different, type of answer that we're going to have. It's going to be more fleshed out. And so I think, as you said, it's commensurate with the level of funding that you're looking at. But I would say in the life science space, they're going to want to know early on, many of them, that you're starting to look at this.
And can I just
Of
follow
course.
up on my
Go right
to
ahead.
follow up on Brian? I mean, part of our job as a law firm that counsels our clients in IP is we help them develop that language, help them, address give them the tools they need entering into a financing round or even a specific discussion with an investor. So, if you are starting a company and you're looking at questions of FTO, of course, I'm an attorney and I'm biased, but I suggest you reach out to an attorney, even if only to get some thoughts about how you might answer the question. Because I think sometimes if you're not an attorney and you're speaking knowledgeable about IP, you might say a term that you might not fully understand like the breadth of. So, we work very closely with Brian and he's excellent at, he's very savvy. He doesn't need much of our help in regards to this, but he's someone where we've worked with him over time. That makes sense.
That's great. Thanks. Peter, I have a question for you actually on this hypothetical of approaching it, different funding stages. What's the answer if a potential investor wants to see either your FTO opinion or your search results? How should someone handle that?
Yeah, we try to counsel clients not to share anything written, right? So to the extent there are written opinions, that's a privileged document between us and client, right? So things, if at all possible, we try to have a kind of a lesser summary page that can be shared or shown. I see slide decks all the time. We're free to operate. These are bold statements and can be taken as reps and warrants, and I don't think we want to get there. So I think we can say we've studied the landscape, we understand the market, however you want to phrase it, but and then show. I think Brian, you mentioned it earlier. Certainly an awareness of what's out there, kind of an understanding. I know the language, I know the competitive landscape. These are kind of subordinate purposes for FTO searches and work that our firm does. The kind of the market and competitive intelligence that can inform the client, the innovator, the company, and they can share that much. But I think as far as you can do this, but not that, kind of the hard and fast opinions, those are not to be shared. Did I answer your question?
You did.
Okay.
He usually doesn't, but you did that time.
This one
that was
gets
good.
me. Okay.
I was just going to add like some other things you can do along your not writing things down, sharing it like email. I know we did this with one investor that was very, very prominent. We brought them in and literally had a meeting with the law firm. And we kind of did it more of a verbal show and tell. And it was, again, just to bring awareness, competence. And they left, obviously thinking like, hey, we're opening the door to that, and so that was like a good way to build confidence.
So you shared slides?
Well, we didn't actually share the slides. We brought them in and we presented slides.
Was there an understanding of confidence?
Well, we had confidentiality in place, but I think it was, again, just back to my earlier point about, the question, do you have a quote, freedom to operate is fundamental? Yes. But is this company, are they thinking at the right level?
Right.
Do they have counsel around them? Is the counsel competent? Right. And so are they answering the right questions to get that answer? They don't have the time to answer all the questions, but are they, as a surrogate, are they surrounded with the right thinking? And so there's things you can do around freedom to operate rather than the actual tangible document itself.
Right.
Yeah,
right.
I think that's perfect. When we spoke earlier last week, I think, Jay, you had some thoughts on the written document versus just having it oral. How do you handle that in your practice?
Typically, we don't produce or have a written document produced. There's a couple of different scenarios. So I've been at Markforged for about 4 years. When I joined, we were a startup organization. Since we have gone on the public market, at the time we were doing a number of different investment rounds, and in that process or through that process, we were looking at these kinds of issues. And as we went through the diligence process to go public, I guess, to go on the stock exchange, we had those same evaluations. And in similar circumstances, we presented information, and information was presented or evaluated against us. And in each of those circumstances, it was the question really was a question of credibility. It was the being able to be out ahead of what anybody else was be able to do. Now, how that information is presented and conveyed is really for us the question, and I think that's is the point, is being able to share that information and make sure that you're reasonably fulsome and be able to capture as many of the issues as you can. And if you're not, and if you're missing something, be able to understand and be able to capture something. If there's a competitor or an aspect of the freedom to operate that you're missing, be able to capture why it's missing and understand it, be able to circle back around on it. Those are the kinds of things that these folks are going to be looking at.
Are investors asking for representations and warranties that you have done the search, that you don't infringe knowingly, right?
Yeah.
Yeah. So I've been on both sides of those. You'd love to get those reps, but I don't like giving them.
No.
There was a lot of laughter on that one. Any other comments before we move off of the privilege, reps, and warranties? How to memorialize these opinions?
I could say a
ahead.
little bit more about an earlier stage, like output,
Please.
so if you might be, a new startup company and interested in learning more about the FTO, and, that might be a simple phone call with your attorney or the person who did the work, and get a sense of, so let me maybe back up for a minute and tell you, like, the way that we do FTO, I don't know if we're going to get into this, but there are many ways depending on the technology. But I might come up with a simple keyword query and look in, let's say, some kind of database. I might then get a set of results, patent hits, and then I would review them. And so the output may simply just be a phone call to my client and talk through it was clear, or maybe I would watch these 3 families, something like this, and then that's that. So there's truly no other written output. It goes all the way to what Jay was referring to, and Peter, like an actual formal opinion rendered by your legal counsel, saying that you haven't identified a third-party position that would pose a problem for FTO for you. So it could go either way, I think.
But I think what can also be helpful for young businesses, I found, we just had one on the phone last week or so. On the phone. No, it was a Zoom call.
I still use my phone.
On the phone, whatever.
It doesn't matter.
And I can see it was a very young startup, and our attorney, our general attorney, told us we should do FTO. I said, wow, okay. I said, let me help you through this, because I think the company itself, the young company, can do a lot of the early kind of ground level work.
Yeah.
They know their business. They know where they want to go. I can teach them how to do searches, but they're closer to the technology. So what they find, I can walk them through. So there's efficient ways to get at this and to kick it off.
Absolutely.
What are some of the
Stealing my
parameters?
Did you have that?
Go ahead.
Yeah.
I'm sorry.
What are some of the parameters that startups should be thinking about when they're constructing their searches? Anybody?
I mean, I'm happy to talk, but I'm sure everyone here can comment. What we usually do is, when I will sit down with a new company and they ask me about FTO, we are sometimes also thinking about an unrelated issue. I won't get into it. It's not the topic of this, but it's called patentability. But we'll think a little bit about FTO, and we'll think about a keyword query. Like, let's say this cup, I might say, cylindrical, open, like white, whatever it is, some words to describe the cup. I might also think about, who do I know? Who are the individual players in the field that develop cups? And I might have an inventor list. And then I might also think about, who are the big companies out there? Who are the big cup companies, Solo, et cetera. So I would have those 3 prongs, and then I might do a search like that. But then I think it's very important, to Peter's point, and Brian is a good example of this, if you don't mind me embarrassing you, but he is an inventor and a CEO who is deep in the technology. And so we would originally make these queries, and I think he and scientists and inventors like him are the ones that are best suited to maybe review those results and really tell us whether or not their technology is related to the hit that we'd see,
And it's, I mean, exactly the keywords, but then there's like how you join keywords, right? Or you may find different results, right? And so it's often not just one word that's going to be the magic word. It's going to be a combination of words, right? Because there's a lot patented out there. So it's pretty difficult to just have a claim with one word, right? So it's gonna be combinations of words. And so you have to try and fit, it's like a puzzle, right? You have to try different things. But as she said, you have these parameters and you can use software that's available today, whether it's Google or you can pay and do subscriptions to patent softwares. There's AI powered software and you get access and they do patent landscaping like you were talking about. They build maps. And then you can run queries in workspaces that deliver results on a recurring basis. So you have like an active surveillance program. So you can use technology to help generate the search, but you still have a human interaction at that point where you have to start figuring out what does all this mean, and then you can sort of parse it out and then have the educated conversations pointed with your law firm, right? And so that's a good way for the entrepreneurs out here to like hedge some of the costs, but actually make it meaningful and make it and helpful for your cause.
Absolutely.
That's great. Thanks, Brian.
Excuse me. Does
Yeah, go
everybody know what a patent
I was going to
is or-
say,
or
do you
looks
mind?
like?
Yeah.
I didn't want to get too far ahead of the crowd. Well,
Define patent. Oh, boy. That's,
Yeah.
well, it's a
oh,
right.
this just took,
it's
this
real,
took a turn. Now we have 25 minutes to talk about patents. Go.
Okay, real quick. So a patent is a right to exclude others from what you claim. Okay, but just structurally, have we all seen? I know this half has. Have we all seen patents? You all seen a patent? Because it's a gold mine. So when we talk about searches, if you know how to read a patent, not just the claims and as we do give opinions on what's being claimed and the scope of those claims, but the bibliographic information up front. You mentioned inventors and dates. How long did it take from filing to issue? What's the pace of innovation? Then there's a list of prior art that gets cited in the patent. So now I have a whole bunch of references I can look at to see who's out there, the same inventor names, the pace of innovation, the dates, the art units at the patent office, the same examiner names. I haven't even turned the first page, and I've learned a ton of information. So patents, starting your own search, finding those early patents, it's like a thread you pull on, and it just keeps going. And so if you know how to read a patent well, there's much to be learned. I'll leave it at that.
And I think, Peter, what you're touching on too is what we opened with, is that there are so many different purposes for
Oh,
FTO.
yeah.
It can be, see, look, I tied that in, huh? We got off on patents, we're coming back to FTO.
She's terrific.
But no,
yeah.
it could be for early landscape analysis all the way up to, unfortunately, you got a cease and desist letter right after you launched your product.
But and companies, established companies launching new products, they want to know they can do so, right? And build on what they have, or enter an entire new collaboration or a whole new marketplace that they haven't touched before. That's happening a lot. I'm sorry, you had a.
I don't know.
Okay
Do we
questions?
need, you can ask
Excuse
the
me,
question.
if you
I think
have a
that you need to
question,
bring
yes,
them a
please
microphone.
give me one moment.
So thanks for bringing up the patent, and I wanted to ask, just because you said patent gives a right to exclude, right, people from, so does when I filed a provisional patent and I'm thinking about turning it into a patent, costs money. So the question is, how does a patent help you with freedom to operate? What is the relationship between them? Probably meant to cover it anyway, but.
I know we can all answer that, so I'm gonna.
Oh,
Give it-
that's your job.
I'm giving it to Jay.
okay. Well, actually, a patent doesn't actually guarantee you freedom to operate. It does help. The examiners at the patent office do a nice job on a search of it, I will say. They're not probably the best, but the idea is that if the invention that you are going to commercialize and put out in the public matches what is going to be claimed in the patent that you're having examined, that correlation is examined at the patent office. The examiner will do that search, and that should prove fruitful for you. The difficulty is when it doesn't match up exactly. That one-to-one correlation is nice. Otherwise, the search and having the features of whatever your product is, those features, that's something that you know. And the examiner is looking at the text of the claims in light of the specification that you drafted. So what the examiner has is the document. Now, it may mirror the product that you've made, but the product that you're making is what's going to go out and what's going to be for sale in the public, and what I'm going to call him the bad guy is going to sue you on with their patent document. So that's why freedom to operate is a little bit different than patent or patentability or those. That's why Angelin brought up the patentability search, and your ability to patent it and have your rights are a little bit different than freedom to operate.
I can give you an example. So let's say you got a patent to this cup. Your claim might read a cylindrical, open-ended device. There might, and that's great. And now you have the ability for other people to make and use and sell that. But there might be another patent out there that says a method of delivering a liquid to a person, right? And that might cover what you're intending to sell the cup to be used for. So you might not have freedom to operate under that claim, if that's a valid claim, right? So that's what Jay's getting at. So you have to make sure, so freedom to operate helps to ask, is there another claim out there that's in force that would prevent you, that you would ultimately end up infringing if you move forward with your product? And it might be different than the patents that you're drafting and pursuing in the patent office.
Oh, and you may need to obtain a license to practice your patent and through your product. So your product may need to obtain a license to the senior patent just to commercialize your product, even though you have a patent to the narrower claim.
And that's another purpose of an FTO, which is to uncover any licenses you might need to pursue.
Yeah.
Andrea, can we have next question, or should we wait until the end of the
What do
session?
you guys want to do? More questions, or wait until the end? Okay, well, we'll wait until the end. I'll just,
Thank
I don't know, maybe 5-10 minutes at
Sure,
the end.
thank you.
Only thing I was just going to add to that is there's a temporal component to all this too. So again, back to the life science, it might take me 10 years to get my product to market. And there may be a claim today that would prevent me, but it may be a patent that expires in 5 years, right? So there's a temporal component to it. You need to think about that.
Yeah.
That might inform you, keep going, right? Or whatever. But
Like, don't pursue a license because it's,
Yeah.
right.
Right. That was actually a question I was going to ask for Angela. And when we were talking about inputting parameters for constructing your searches, should you be considering the launch date, especially in life sciences where you have a long lead time?
I actually don't do that. I like to see everything with as few filters as possible, unless I'm looking at thousands of results. But I do, once I get the results, I might, because I want to be able to, like, sometimes I'm supporting a client in raising money and they want to know right now, like, what is out there. But then we can say, well, we're not so worried about this because this will expire next month, you know, but there might be an ability to continue that patent or something. So I don't necessarily like to filter out. I like to know more, and then I might remove something myself.
Yeah, I think that's a
great.
dangerous approach. I mean,
That's
there's
great logic.
there is a look back period in patenting if infringement happens prior to the expiration. I don't like playing that at all if I can avoid it. I'll leave it at that.
That's
Yeah.
excellent insight. Does anyone have experience with doing combined patentability and FTO searches? I know a lot of companies do them separately. Is there a benefit to doing them combined, or is that just getting too complicated? Anyone?
Happy to answer, but if anyone, I've been talking a lot, so feel free to.
Angela, it's all yours.
Okay. So patentability and FTO ask different things. And so sometimes you can combine them, but the way that you analyze the results is different. So I might come up with my cup query, right? And I might do the search. Those first steps are the same. And then I will get a set of results. And then I will ask the result to tell me something different to answer the question of patentability versus freedom to operate. So for patentability, I'm saying, is there another position out there that discloses my cup? Because if there is, you guys might know this, in order to get a patent, you have to show that your invention is novel and not obvious over something else that's out there. So if somebody else already invented a cup that looks just like mine or is like red, and I want a white one, that might be an obvious alteration. And thus my patentability search would tell me, look, you might be able to get this, maybe, but there's something else that's very close. So I read the results to say, is my invention already disclosed in another position? Also with patentability, I don't necessarily care if there's an issued patent or not. I just want to know if it's disclosed, whether it's in the literature, on a website, in someone's senior thesis, that, it doesn't matter that it's in an issued set of claims. FTO, I'm reading the results to say, I'm only looking for issued patents that are in force that someone can sue me under. Should I continue? Okay, sure.
I would just say, and
Is
if
there
you use
fire?
them together like
Yes.
that, from a business decision
Can I say
standpoint.
something? You don't have to combine them.
In combining the search, you're looking at sets of information to help you make decisions as a leader, right? So it may be that, like for our situation, we have a material that could be used for many uses. We also have a decision to make. Do we invest the money to go after that application or this application?
Right.
Oh, wow. Looks like there's a lot of activity over on this application. I may use that information to help steer my development process.
Patentability.
Exactly.
Right.
So it could be used together to help make business decisions on where to go with your development or your commercialization strategy.
I would also look at that as another term of odd called the design around, to which, as you look at the claim strategy from a commercialization standpoint, looking at as an opportunity, also looking at it to see what the potential risk is in the patent market, and working internally to avoid that space. And that's just, we would call that a design around to avoid that particular landmine.
That's a good point.
So I have no idea what anyone's been talking about for the past 3 minutes. I'm going to throw out an option. Do you guys want to talk about cost considerations, or is that not? I don't know what the last few sentences were. Is that a good segue right now, or do we want to go somewhere else? I know. So sometimes
Questions too?
yeah. Well, we can take some. Are you guys okay with taking questions? I was going to offer in 2 minutes anyway. Yeah, let's do a couple questions.
I had one queued here, so I'll start from here and then.
Sorry, I have 3 quick questions. One is, you mentioned, if it's so important, you mentioned that you don't have one yet. I'm just wondering why you have not gotten an FTO. The second one is, when you're doing a search, are you able to do a search of applications as well as a patent?
Yes.
And the last one's the hardest one probably for you, I'm sorry, is it sounds like you're mostly biotech and not high tech, but if you're planning to have open source software, how do you walk between the raindrops?
Do you want to answer why you don't have FTO?
Yeah,
Or
I
you
mean,
answer?
I think going back to like when you describe freedom to operate, it could be many things. There isn't like a hard definition of what freedom to operate is. Conceptually, we've done that. We've been on the phone, exchanging information, doing searches for 8 years now. We have a very good idea of that space. Is it documented so that if an investor absolutely needed to see something written before they signed a check, we could put that into place, right? And so that's kind of the thought process there. Yep.
Yeah, that's a good answer.
What was the second question?
I don't know what the second
Search
question
applications
was.
through patents, and that's an easy yes. It's just a clicking a button. You can search pending applications where the claims either haven't been examined or in prosecution versus only patents that have been issued. That's
Just a little sidetrack on the applications. So patents publish every Tuesday.
good point. Yeah.
So patents issue every Tuesday. So today, patents are issuing.
Hooray.
They publish 18 months after they're first filed, right? So it highlights the need to continually revisit.
This is a very important point, just to underscore
right?
what you're saying. Yeah.
That's right. There's no static environment. So you have to continually revisit your search strings. And as products develop, of course, you go back at it.
So, for example, I file my patent application on the cup
That
today.
cup is
18
being
months, it does
patented.
not publish. So someone else could have already filed a patent application, and you won't know about it for 18 months from the day that they filed their first provisional. So,
Okay. And the third question was about open source.
I don't know.
Okay, so a lot of innovations I work on include an open source aspect, and that's perfectly fine, but you have to know what you're getting into if you include open source software, right? So now you're opening it up to others. So that's not perhaps the wisest approach, but sometimes it's necessary, I suppose. I think informed is the way to walk through the raindrops. Bring an umbrella.
Do you want to move to the next
The mic.
with the mic?
Yeah. Great discussion, by the way. So I have two questions. So there are some new law firms that they claim that they are using AI for IP market research. So is this like a new trend and we should really rely on them, or just like stick to the old firm that we've been working on? If we are not working with the AI-based companies, are we missing something? And the other question is, when we have strategic partners, how we can protect our FTO? Thank you.
And Brian, you have an answer at least for the first one, right?
There is software. I mentioned it. We use it. Just beware, right? Like more AI means more data. What are you going to do with all that data, right? So
And is it real?
is it real,
Right.
right? So I think it's a useful strategy for sure. Again, I appreciate the compliment about being savvy, but we have to really understand the portfolio of what we're getting into with a biomaterial. And, we've just taken a position to invest internally into like becoming educated about what's out there so we can help drive the conversation with our law firm, Lando and Anastasia. But that being said, just beware, right? Like it's a lot of information that can come at you, and then you need to know how to use it.
But I've heard nightmare stories of people putting their own claims into an AI search bar. I mean, I don't think you want to go there where you're adding to the text, you're adding to the database. And I think some naive folks might have taken that.
I didn't hear that story, but that sounds terrible. Now we're all going to leave here
You've
scared.
heard that story. Yeah, people have done that because frankly, it's tempting.
So
It's in
remember, you have
English.
to
I don't
file before you disclose, and the idea would be you've already disclosed by entering your unfiled on invention.
Right.
Right.
You're informing the database with your own inventions. So then the next person who searches is going to, I don't go there.
Angeline, you bring up a great point on the timing of that disclosure as well. Okay, so we should all walk away afraid. That's
There
good.
was there a part A
There
and
was
a
a
part
second
B?
question
Yeah.
from. So the question is a strategy on protecting yourselves using FTO when you're starting a relationship with another company. Yep. Anybody want to take that one?
I'm happy to answer. I mean, you really want to be careful when I think we work with some inventors early on where we want to, of course, enable you to have those great conversations and to enhance your collaboration. But you really also have to be careful about what you share. I mean, again, I point to Brian, he does a lot of these collaborations and he talks to a lot of partners. You, for one, of course, would like to have something like an NDA, a non-disclosure agreement. But even with that in place, I might not share all of the key features of my invention with a potential partner. It's not uncommon that these partnerships don't stay in place, and you then might have that discomfort of knowing you've shared some of your secret sauce with others.
And
I don't know if you
I
wanna
think
comment on that.
sometimes issues are raised when the parties, it's an uneven playing field, right? There's a
Yeah.
large company and a startup. So this is not, an NDA is not going to save you there, right? So,
But Brian does a lot of this. I don't know if you want to.
oh,
Yeah.
I'm sorry.
No, I mean, we work with a lot of surgeons and, we want to develop our product, test it with them. And so we're sharing ideas, and of course they have ideas, which is great. But before we do that, we put together IP sort of ownership clauses in our agreements so that anything that's developed, in the scope of these discussions would then return, to the company, in our case, our company. So that's important, like you said. But there's other types of partnerships, like strategics, like you said. And it gets really tricky as well, because even if you have an NDA, some of them, they won't sign, the larger companies will not sign these NDAs forever, right? They'll have a term to it. So you have to be very, aware of what kind of relationship you're getting into, even if it's just to engage in conversations. So then you have to use the tactics like Angelin said, where you may describe your technology in terms that are not specific to the absolute features of interest, right? So it just gets tricky, but you need to be aware of it because, there's partnerships out there that could help you.
And when there's a term of years in an agreement that has a confidentiality component, what you're implying there is it's not going to be a trade secret for long. So it's not always what's in the patent. It's the interstitial information around the patent that makes technologies work many times, right? It's that know-how, it's the trade secrets. So as soon as there's a date in an agreement, what you're saying is in 2 years, I'm going to lose my trade secret. I'm going to allow them to go with it. So first and foremost, when there's a collaboration of any size, I encourage clients to get into these collaborations. As I said earlier, I think 1 + 1 often is more than 2, but don't trust. Always file a patent application and then limit your conversation to what's in the 4 corners of the document. Don't go beyond. We all like to elaborate. Save that for another time.
Thank you.
Hopefully
We
there's
have
enough in there to entice
4
them.
minutes left till
We
the
can-
end of
Oh,
the
I'm
session.
We'll take one more
Can we
question.
take one more
and then-
question?
And then we'll wrap up because I know there's one in the front row that's been
I
waiting.
had one and
Oh, okay.
sorry, yes.
I won't answer anything.
Hello. I'm a student here at Suffolk, and I have like this business idea I've been working on that I want to do. And it's like, I guess in a similar fashion to like Fiverr, that how you have people work on the site and then you basically take a percentage of the cut. But I wanted to ask, what's a good percentage of the overall price for somebody's like offer or work they do, and how do you convince, I guess, like currents or like communities of people to rather work on that site compared to their already established platforms, either on social media or other sites they use? Like what's a good thing to use to, like, I guess, garner them towards your company, if that makes sense?
I don't know. I'm not sure. Does anyone want to take that one, or do we? You know what? I'll say this. After the panel, we're all available for specific questions. And we're actually, if you would like to come to, we're having an after party. That woman in the back, her name is Jess. She's in black with pretty glasses. You can ask her and she'll let you know where our after party is going to be. You're all invited. So I'm sorry if we didn't get to your questions, but you can bring
one
them for
more.
that. Yep.
Thank you guys for coming in today. I'm sure everybody really appreciates it. Brian mentioned the cost considerations of filing separate patents for different applications. My question to the fellow attorneys over here is, like, why not file the patent, and in the patent you say, okay, this cup is a cylinder with a closed bottom and an open top, and it could be used for this application, and this application. Why can't you do that all in one patent? Thank you.
I have this conversation every single day. Not about the cup, but but that really gets to patent strategy, right? And thinking about, what do you want to use your patent for, right? What do you want to use the cup for? Like, are you going to partner with other people? So maybe you're going to develop the cup. I'm sorry about this cup analogy. It's just kind of like, but like perhaps you want to, give it to one company, and then you want to use it in hospitals, and then you want to use it for a party supply store. So that might make sense to split up the invention for a number of ways, because you envision using it in a number of ways, different ways. You can certainly put everything in there. And you can get sets of claims. You can have one set of claims on one use, another set, and then follow a continuation application and get a second set of claims. But we spend a lot of time thinking about how to craft our inventions and cover things so that you have flexibility. I'll also say, when you file a provisional application, it's only pending for 1 year. And in order to get claims ultimately issued, it's helpful to have data in your application. So,
Angelin, I don't want to interrupt you, but they're going to cut the video off. So before they do that,
I'll leave it at that.
I'm
then,
sorry.
yeah.
We're available for anyone to talk to
Yes.
after. I want to say thank you to all of you for watching, and thank you to Startup Boston, and of course, our panelists.
Thank you very much.